We need to take a moment during our discussion of the statutory authority of a Texas peace officer to make both warrantless and warrant arrests to review when precisely that arrest occurs, or, in other words, when a person is considered to be in custody. This is important in a legal sense because an arrest itself is a seizure under the Fourth Amendment and must be reasonable. Further, once an arrest is made and a person is in custody, the courts have ruled that a search incident to arrest may occur in order to protect the peace officer from any potential weapons on the person or prevention of the concealment or destruction of evidence. In addition, constitutional search and seizure protections aside, once a person is under arrest or in custody, many additional rights are triggered. For instance, protection from self-incrimination. The Texas Penal Code and Code of Criminal Procedure provide definitions of custody, constructive custody, and restraint. But just like a peace officer needs both probable cause and statutory authority to arrest, when exactly a person is considered in custody is a matter that must be informed by case law. So, the bottom line is, despite these definitions we are about to review, determining the precise moment when a person is in custody is not always the moment, for instance, when handcuffs are applied. With this in mind, let's review some statutory definitions from the Penal Code and Code of Criminal Procedure. First, according to the Texas Penal Code, custody means under arrest by a peace officer or under restraint by a public servant pursuant to an order of a court of the state or another state of the United States, or under restraint by an agent or employee of a facility that is operated by or under contract with the United States and that confines persons arrested for, charged with, or convicted of criminal offenses. Essentially, in a jail, prison, or other sort of government criminal justice related facility. Next, according to the Texas Code of Criminal Procedure, the words confined, imprisoned, in custody, confinement, and imprisonment refer not only to the actual, corporeal, and forcible detention of a person, but likewise to any coercive measures by threats, menaces, or the fear of injury whereby one person exercises a control over the person of another and detains him within certain limits. Finally, according to the Texas Code of Criminal Procedure, restraint is meant the kind of control that one person exercises over another, not to confine him within certain limits, but to subject him to the general authority and power of the person claiming such a right.